Hey everyone, welcome back to Glass Radner's Business Interruption webinar. Today we've got a special guest, and that is Erin Dunnavant with the law firm in Tampa, Florida of Danahy Murray. We've worked together a bit over the last few years, and one of her articles kind of caught my eye, so we wanted to bring her on to talk a little bit about that. So Erin, thanks for joining us, and if you can give us a quick introduction about you and your firm. So how did you come to be represent some of the policyholders and give us a little bit of background on yourself?
Sure. As Mike said, I'm Erin Dunnavant. I'm with the law firm of Danahy and Murray. I have been working on behalf of policyholders now for just about 10 years. Recently joined Danahy and Murray, though, at the beginning of 2019. So was really excited to join the team here. We've got a great group of lawyers, and we're all very passionate about what we do here.
Okay, great. Yeah, so being a fellow Floridian, obviously, we've seen the news this week. It's August. We've already had a landfalling hurricane, and I'm sure the way that 2020 has gone, where it promises to see many more behind it. But for policyholders where they may have some effects of the hurricane, I mean, do you have any sort of practical advice? I know one of the things that you've been written about was specifically in terms of notice, and what do you typically advise clients in regards to giving notice of claims?
If you suspect that you have damage, it's probably best to go ahead and report it as soon as you discover that damage. Some people hesitate to do that, but I encourage policyholders, homeowners, business owners, all to make those claims as soon as they think they have an issue, only because evidence is always better if it's collected closer in time to the loss. Not to say that it can't be collected afterwards, and we have those cases, but it's always best if you can collect your data or have your insurance company collect your data as soon as possible after the storm.
Right, and you always hear about business owners and you know, even on the personal line side of people that think that maybe their premium's going to go up, or I mean, what are some of the other reasons that you may see that people don't report, and then that in your experience?
Right. So some people are really scared to make an insurance claim. They're scared that their insurance company is going to cancel them. They're scared that their premiums are going to go up, like you said. They're scared that maybe they don't have enough damage to meet their deductible. On some claims, the hurricane deductible is very high. However, what is the flip side? Well, the negative ramifications of not reporting a timely claim can be even worse, right? Because what if your insurance company says, well, 3 other storms have happened since, you know, Hurricane Irma or Hurricane Isaias. I can't tell what's because of this and what's because of that.
Right, yeah, and the effects of these are not immediately known, but obviously you want to maintain and just kind of keep those your legal rights. So would the same then also go for those businesses that may actually have COVID claims, where you know, would you recommend that even if you don't necessarily think your claim may rise to the level, or you may not necessarily have the coverage, but you still would notify?
I would encourage business owners, small and large alike, to go ahead and put in the COVID claim if they think they've suffered a loss because of that. And just like with a hurricane loss or any other type of loss, you know, and one thing we didn't talk about either with regards to both are a lot of policies require prompt notice, immediate notice. So while you might have more time under the statute, many policies require prompt. So a lot of courts are interpreting prompt maybe a little differently and a little bit more stringently. So keep those issues in mind as well. But yes, I would encourage anybody who thinks they have a COVID claim, whether it's a business interruption issue, a civil authority issue, or anything like that, to go ahead and make the claims. And
right, and then you made the distinction also between, there's a difference between your duty to notify your carrier versus what that statute of limitation might be, you know, if you don't get a satisfactory response, correct?
Yes. While the statute of limitations are different all over the United States, in Florida, you have 3 years to report a hurricane claim, supplemental claim, or reopened claim, okay? However, you actually have 5 years from the date the storm made landfall to sue your insurance company for a breach of contract. That doesn't mean you have 5 years from the date the storm made landfall to report your claim. That means you have 5 years if you have a problem with the way your claim was handled, it was underpaid, it was denied, there was some other issue about the way the claim was assessed. That means you have 5 years from the date the storm made landfall to fight your insurance company if you were not happy with the result of your insurance company's decision. So
right, and that certainly jives with what we're seeing, where we've talked to a lot of big policyholders who, you know, they've given their notice and then their claim has been denied, and now, you know, even though there is a lot of claim activity and litigation going on, a lot of people are just hanging back and waiting, and they're going to use the 5 years to kind of see how the litigation shakes out. Well, we'd like to thank Erin Dunnavant of Danahy Murray for giving us their comments and their thoughts on notifying your insurance carriers. So we look forward to seeing everyone back next week for another episode of GlassRatner's Business Interruption webinar series. Thanks. Bye now.